That seems good enough. Good morning and thank you for joining us today. As always, we're going to start with our housekeeping and instructions. As always, this is general information. It is not legal advice, so don't go and say, oh, condo law said this and try to use as a point. It's just general information. You can only get legal advice from your association counsel in a more private setting, even if we are your association counsel. Please keep in mind that the chat function during the Zoom is intended for questions or requests for clarification and not for providing legal advice or a general chat that you might find elsewhere. I don't think ever had this as long as I'm doing it, but if you have a question you want to unmute yourself to ask it, go for it. But otherwise, please keep yourself muted just to minimize background noise. In the chat, Chelsea, could you put the link for the Monday morning minute? The Monday morning minute is what the WSCAI Legislative Action Committee puts out during the legislative session to keep you updated on what's happening in Olympia, any bills that might be of interest, and sometimes there are calls to action that come through it. It's a short read, but it's an opt-in thing, so if you don't want it, don't click the link. If you do want all this information, link is in the chat below. We have another CTA news update because it never ends. Recently, this past week, the Treasury Department announced that it will not be enforcing the CTA against U.S. citizens and domestic reporting companies. The Department of Treasury is looking to narrow the scope of the reporting requirements to foreign companies only. However, Congress passed the law as it currently exists, and the law itself is, or until the law itself is changed or eliminated, the lowest risk option is still to comply, because basically the law still exists, you still should comply. The Department of Treasury is just saying that they're not going to take any enforcement action. So we will keep you updated if there is another change in the CTA, but that is how things are as of 10:03 today. Okay, and before we get into our questions, we're going to start with a little non-submitted question. If Ken, you want to take it away.
So what I wanted to do is cover a little bit about insurance, because we've had, it seems like, an increasing number of clients come to us where some damage event has occurred and they've submitted to their insurance, and the insurance company has given them nothing, or given them, $20,000 for a $300,000 loss. So I wanted to make sure that people understood that they could actually get copies of their insurance policies and understand better what they are buying coverage for. So the insurance policies have a whole section on exclusions for your property insurance policy, and then even the general liability policies may have exclusions. And it's important to understand what some of those exclusions are so that you can better understand what you're buying protection for. We have seen clients buy low-cost insurance policies because they had a lot of exclusions, but the client never understood they had those exclusions. So, for example, you can buy insurance policies with rainwater exclusions. And the rainwater exclusion is going to mean it doesn't matter why the rain is coming in. If your building is leaking because of rainwater, you're going to have no coverage of any kind. And there are routine exclusions for floods and for water seeping through foundations and for mold and fungus. And all of these are things which create losses for communities, which you may or may not have any insurance for, but we would prefer you actually know whether you have insurance for when you're making the buying decision. Okay. Frequently, when a client sends me a letter that's rejecting a claim they've submitted to their insurance company, I will say, do you have a copy of the policy? And the answer is, in 90% of the cases, no, they do not have a copy of the policy. And I'll ask for one, and then they will send me a 10 or 15 page long document, which is the bill they got when they renewed their insurance. And they think that's the policy, and it's not. That is just a declarations page and an invoice for the insurance which they're buying. Most of the actual condo policies are upwards of 150 pages. They may be over 200 pages. And it's because there will be a huge list of documents, often 20 or 30 documents, which make up the policy. It'll start with kind of the standard policy language, which might be 16 pages. Then there will be the terrorism endorsement, which is required by the federal government. Then there will be Washington state changes. Then there will be condominium changes if they're a condominium. Then there will be changes to specific provisions. So like frequently there will be a change to the water damage provision. Then there may be endorsements which provide additional coverage or exclusions which are more exclusions than what are written in the original policy. And so when the claim is submitted, the insurance company goes through these 200 pages and finds all the language that would prevent them from providing coverage because that's in their interest. They will write a letter, and they're required in the letter under Washington law to state the policy language they are using to justify not covering your claim. And so they will cite, a dozen paragraphs out of the 200 some pages as why they're not providing you any coverage, but they're not going to tell you about any other parts of the policy that may actually offer coverage. And so if we're going to try and provide a reasonable analysis for you of whether or not the denial is appropriate, we need the full policy. It's not difficult to get this. Your insurance company has to provide it. You just have to call your insurance agent and say, please give us a copy of the full policy, and they should be able to send it to you in a PDF. So what we would prefer is that every association is looking at the exclusions and endorsements when they are making their renewal decisions. And especially if you're changing companies, it's important to know whether you're buying the same coverage as you had before or something different. One other thing which a lot of policies have are not flat out exclusions, but they'll have a limit on how much they'll pay for a specific kind of loss. So this is very frequent with sewer backup or drain backup, where they will have a different deductible for that kind of loss, and then they will have a maximum payout. So we had a client where they had a sewer backup, and they had I think it was $100,000 loss or so for just the water cleanup. And their deductible for that water loss was $50,000. And then the maximum payout was $25,000. So the insurance company doesn't have to pay out a dime until they hit 50,000 of loss. And then the insurance company only had to pay out 25,000 regardless of how much damage there was, because they had this cap. Now, I think of that as being like an exclusion, but the insurance agent will tell you, no, that there is coverage for sewer backup. It's just limited to the $25,000. And many individual homeowner policies will have the same kind of exclusions and limits on coverage. So I had for my homeowner's policy, the insurance company wanted to put a $5,000 limit on how much they would pay for a sewer backup. And I can tell you that that covers less than 1 day worth of cleanup if you were to have a flood into your home. So, there are also some exclusions in general liability policies as well. We had a client once where one of the owners was convinced that the board was pumping poison into her unit through the ventilation system. And the insurance company did not want to defend the association when it was sued, claiming that the pollution exclusion was going to prevent any coverage. And that was one which we were successful in challenging the denial by the insurance company, in part because what we were able to, I'll say, show was that they had actually not proven there was any pollution. And so they were required to defend the association until they could actually establish that the exclusion applied. But a lawsuit from the owner, they were required to defend, even if they were not required to provide coverage for her injuries if they had found poison was being pumped in. And so if you have a claim that you've submitted and an insurance company denies it, it may be reasonable to have that reviewed by someone who understands your policies, or to have someone read your policy to see what's covered and not. We do this on a fairly regular basis for small claims, but there are law firms that do very specialized insurance coverage work. And the wind-driven rain claims that you may hear about amongst our various community people, those are handled by a couple of select law firms downtown. And there are lawyers who specialized almost exclusively in just finding coverage under some part of that 200-page document, even if there is an exclusion in it as well. And that's in part because under Washington law, if there's any ambiguity in a policy or conflict, it is interpreted by the courts in favor of the policy holder, meaning you, the insured. And so it's worthwhile sometimes to look for an ambiguity and make an argument that there should be coverage based on what the policy holder understood they were buying. And you just need to decide whether it's worth taking the risk to pursue that claim. Anything you want to add, Katie?
No, I think you covered it. So I will jump into the first question, which is, are there any exceptions to appointing directors to expired terms? This takes into account that there are others willing to serve on the board. So first, we're not exactly sure what you mean by exceptions in the question, but we will do our best to answer and provide information. From the get-go, the community always has the option of calling a special meeting to remove board members and elect new ones. You should look in your bylaws for the specific requirements. It may vary. If there is an expired term and a vacancy, there should first be an attempt at an election to fill that vacancy with a duly elected owner at the annual meeting. If you cannot get a quorum at the election, the board can appoint someone to fill the vacancy. They can do that by statute and the bylaws. They could even just do it at a board meeting if they don't want to try and have an election. The board can fill the vacancy with a volunteer, or they can ask someone that they want to in the community if that person is willing to serve on the board. They don't have to send out a call for the owners to volunteer. The board also doesn't need to appoint someone to fill that vacancy, but it can. It could leave the vacancy open until the next election. Some bylaws and declarations may limit how long an appointed board member serves. For example, it may say for the unexpired term, which could be more than a year, or until the next annual meeting, which is likely less than a year. So that will depend on what your governing documents say. Ken, anything you want to add?
Well, the only thing else I would comment on is that if you don't get a quorum, the board members that are in place continue to serve. So it may be that their term expired, but they're still a board member and they still continue it. You don't have a vacancy created by the failure to get a quorum at the annual meeting. Now, you may have a vacancy for some other reason if a board member resigned, but you don't get to declare that a board member whose term is expired is booted out if you don't get a quorum to elect someone new. that person would continue to serve under the way Washington law is written. And if you've got something specific in your documents, it might change that, but the standard is board members continue to serve until their replacement has been elected. Next question. Our association recently contracted with a management company. All board meeting dates are posted on the website used by the management company and are accessible to all owners. May we post a general agenda for monthly board meetings on this site? Okay, so we'll offer a qualified yes. You can certainly put the information on the site, but that doesn't mean it's going to qualify as notice if you're required to give notice to someone. So the fact that it's available is nice, but being available on a website doesn't meet the qualifications for notice, even if an owner has agreed to accept notice electronically. And that's because the statute says that if you're posting something on a website, you still need to send an email by the method approved by the owner, telling them that the website has been updated with new information. So if you've got owners who've agreed to accept notice electronically, then that would be a way to communicate with them and tell them that the website is updated. I suppose you could send a letter out to people and tell them that the website has been updated. But if they haven't agreed to electronic notice, you might still need to mail them a piece of paper that says when the meetings are. The agenda aspect of this, I think, is slightly different than giving other types of notice. It's unclear when an agenda actually has to be posted in advance of a meeting. If you know about the topics to be addressed, it's nice to tell people what they are. It's unclear whether or not an agenda item that comes up, say 3 or 5 days before a meeting has to be delayed until the following month's meeting. And it may depend on the subject matter and some other particulars about it. But I would say for now, we generally advise that you're required to make the materials available to an owner in advance of a board meeting, but I don't think you're required to actually have the agenda 14 days in advance. But it's also a matter not resolved by the courts yet. Anything you want to add, Katie?
Only that if you want, and which we think is a good idea, you can, even if you don't know everything that's going to be discussed at a given meeting, have a sort of standing agenda that includes approving the minutes. If you're an open meeting requirement community, the owner forum, and I don't know, regular, how's the maintenance of the community, and just general things that you talk about every time. And then you can have that and then fill in as needed, so you at least have something to work off from. All right. The next one is the board allowed to update owners' mailing addresses using the tax assessor office records without the homeowner's consent? Short answer is no. You can mail things to more than one address if the owner has it on file, meaning their unit address with the tax assessor and the address that they provide if they have an offsite location or a PO box or something. But you can't stop mailing to the original address that the owner has provided on file. The notice statute requires that notice be sent to the unit address, so whatever the physical address of the unit is, unless the owner has requested that that notice be sent to a different address or another method allowed by statute in the governing documents, so email. So basically, if the owner tells you what address to mail something to, you have to use that address. If you have two addresses, the least risky option is to send it to both. And sometimes we see this when there's a tenant in the unit and then the owner lives somewhere else, but you need access to the unit with the tenant in there, then it's reasonable to send it to both. But at the very least, you have to send it to the address that the owner has provided and requested that address or that notices be sent to. Ken, do you want to add anything?
Well, there are some specific circumstances where providing additional notices might be necessary. You know, I recall at least one court case on a foreclosure where the court held that because the management company knew about another address that they could or might reach the owner with, that the use of the designated address was not good enough. So I could see if you were doing something like a foreclosure, you mailing it to the unit because the statute requires it, mailing it to the address which the owner's given you because that's the one they've given you, and then also mailing it to the address on the King County records because your goal is to accomplish notice and you don't want to have that challenged if you're going to court trying to get a default judgment. Those are my thoughts. Next question. I have a follow-up question with regard to open meetings. Our building, which is an older building working on the old laws, has several committees. Will they too need to hold open meetings with published agendas? There are meetings for ACC changes, challenges to fines, as well as general social events, financial reviews, and safety issues. So we can't answer because this is not legal advice and we don't know the specifics about your community, but what we'll offer is it will depend, in my mind, mostly on what the purpose of the meeting is and if it is exercising any board authority. If the committee is exercising any type of board authority, which I would think the ACC would be, then I think you need to have open meetings. And if you can publish an agenda, yes, publish the agenda. The exceptions might be that some decisions, and maybe enforcement is one which could be done in executive session. So you could do the same thing with that committee holding an executive session. And the other might be if it is entirely an advisory committee, and maybe the social committee qualifies as this, then that committee can have a meeting and plan and then bring their recommendations to the full board so that the board is conducting the open meeting with discussion and the final decision making. So there's no question that the legislature is pushing for more and more transparency and trying to prevent boards from doing things in closed backroom meetings. And we don't really understand the driving motivation for all that. But I think the answer is yes, you're going to have to be much more open. But I don't think it's intended to take volunteers who are doing things like planning a barbecue and require all of those meetings to become completely open. But it is also, I think, something worth remembering is just because they're open does not mean you're letting all those other people participate. And we think that you're going to end up having to do the sort of owner forum if you're holding a proper meeting, but that would be best held at the beginning of the meeting. So if someone has a comment for an agenda item, they can make it before the board considers the matter. And that's about all I've got on this. You got anything, Katie?
Well, I have a question that came in that relates to this and the notice question before, so I'm just gonna throw it in and then we can move on, which is for question 2 about notice given, does the notice requirement for agendas also relate to committees? For example, the architecture committee, where the architecture request from the owner will be discussed. And I'll give my answer and then you can let me know if you disagree. But I think going back to what you said of how the committee meeting has to be open if they're exercising any board authority, I think the same would apply to notice and agendas. If the committee, the ACC committee or whatever is exercising board authority and has to be open, then the agenda should be sent out and there should be notice just like there would be at any other board meeting.
No, I would agree.
Okay.
I think the only way around a special notice of those is that you have a standing date, like, you know, the third Thursday of every month for all of the architectural review. And then people have the notice in that form instead of separately for every meeting.
Great. Okay. So the next question is, would a rental restriction be considered a change of use and require 90% approval to amend the declaration under RCW 6434? I do not see any 90% requirement in 6490. Would it be easier to add a rental cap after adopting WUCIOA? Short answer is yes. It is much easier, not much easier. It is easier to adopt a rental cap under WUCIOA, but only if your declaration does not also have a 90% requirement. So RCW 6434 does say that any change of use requires a 90% approval to amend the declaration. WUCIOA does not have that. But even if you adopt WUCIOA and your declaration still has a 90% requirement, that's not wiped out by WUCIOA. So Fillmore LLLP versus Unit Owners Association of Centerpoint Condominium is the relevant case that addressed this probably several years ago. In that case, the Division One Court held that restricting rentals is a restriction on use and required 90% approval. But the Supreme Court, when it went up there, they declined to say what the statute required and ruled only that the Centerpoint condo declaration required 90%. So for non-WUCIOA communities, it's still somewhat of a debate about what is required under the statute, but if your governing documents say a certain percentage, that's going to be what is required. For WUCIOA communities, the percent to amend the declaration is 67% unless the governing documents require more, but that more cannot be more than 90%. So if it says 100% and you've adopted WUCIOA, it's not going to be 100%. Under RCW 6490-285, the only amendments that require 90% are creating or increasing special declarant rights, increasing the number of units, changing the boundaries of a unit, or changing the allocated interests of a unit. Those are the only statutory limits for 90%. But again, if your documents require 90% for a restriction on use, that will still apply. Ken, do you have anything to add?
Well, so it just to summarize, if you are a new act condo now with a 90% requirement in your document, you could adopt WUCIOA, then amend your declaration to eliminate the 90% requirement from your declaration, and then you could adopt a rental cap based on WUCIOA. Next question. Is there a risk to the association or board members if a homeowner association, which is not a condo, elects 6 board members, but the bylaws state there should be 3? So, risk to the association board members. The answer is that there probably is some risk because you are not in full compliance. We just don't know how much risk there is. It may be a negligible risk, and it may be a risk which is outweighed by the benefit of having more participation, especially if people are getting along. It's just if you were to increase your board and have 6 voting members and they have a disagreement, well, then the question starts to become, well, which 3 of them are authorized by your governing documents to actually be making decisions, and can you even tell? And so if you wanted to have a larger board, our recommendation would be simply amend your governing documents or bylaws to provide for a larger board and make sure that it is, in compliance with the number you have or want. It's good to have participation, but we see more communities unable to fill the board seats that are required in the bylaws than there are communities with more people who want to serve and volunteer. And it's also possible to have volunteers advising the board without being voting board members. So we certainly have communities where there are a fixed number of voting board members who are elected by the community, so we know they are the ones voting. And then they will have appointed officers who are not board members who are advising the board, or they will have volunteers who are advising the board on specific matters, so that you can have participation and the benefit of a broader community without actually having a conflict between your governing documents and the number of board members. Anything you want to add, Katie?
That if you are thinking of changing the size of your board, and Ken touched on this, but consider the size of your overall community. We've seen some smaller associations want to increase the size to 6, 7, 9, and they're maybe 18 units, which is great that everyone wants to be involved, but again, you're not going to be able to get that many volunteers later down the road, and half of your community being on a board may cause some unintended consequences down the road. All right, the next question is, with WUCIOA for All coming in 2028, is there a handbook being developed to help the legacy HOAs transition to WUCIOA? We are confused on how we need to prepare and proceed. We only have 28 homes, a park, and very little money to invest in attorney's fees. I'm hoping WSCAI or someone will put together something before 2028 rolls around. To our knowledge, no handbook currently exists. There are many resources online, like this Q&A, that can be used. WSCAI is having events in person and virtually that will continue to educate people on these upcoming changes to the law. Like I said, our Q&A is a resource and will continue to be as the effective date gets closer. You can also use the statute as a guide and start looking at it now and familiarize yourself with it. We don't know if other law firms are, but our firm is offering a flat fee to review your documents, to make a list of things that you cannot do as contained in your documents and things that you must do, which are not in your documents. WSCAI is working on creating a guide with this information, but it's in the really early stages and we don't know when it will be ready. That guide may cost some money. I don't know how much it'll be, but that's something to keep an eye out. Ken, anything you want to add?
Well, one of the biggest challenges with the change is that WUCIOA may allow you to do certain things, but the statute won't require them. So some things are required or prohibited. So you must have open meetings, and you're prohibited from taking away a delinquent owner's voting rights. Those are pretty easy to identify. But what's difficult is where the WUCIOA will allow the documents to do something like assign expenses due to misconduct to an owner. But the adoption of WUCIOA does not make that change to your governing documents, and it must be done in your governing documents. So there's going to be a lot of things which people think are going to be happening as a result of WUCIOA, but they don't unless you are also amending your governing documents. So some things like open meetings, they happen whether you revise your documents or not. But something that's related to how you allocate expenses, misconduct, insurance, a lot of those things are not going to be changed. And then there are some things where the statute is written with the sentence beginning, unless otherwise provided in your documents, here's how you do something. So I think the voting section is like that. So it's possible for you to prohibit proxies in the voting for your community, but it has to be written into your document. I don't think that you can prohibit proxies under the Condo Act or HOA Act, but you can prohibit them under WUCIOA, but it is required to be written specifically into your document in order to do that. I don't know why you do it, but it does start with a sentence, unless otherwise provided in your governing documents. All right. Next question. When will the text from SB 5796 be reflected fully in copies of RCW 6490? So the SB 5796 was last year's WUCIOA for All bill. And it also made a number of changes to the text of WUCIOA, which is 6490. And the short answer is that the legislative website was updated in July or August to reflect the text of all of the changes. So if you go on the website now and look at any section of WUCIOA, it will have the current language. And if you scroll down to the bottom, it'll show that the language was updated in 2024. Every paragraph has at the very end, in parentheses, the year in which the statute became applicable or when it was last modified. So some sections will still show 2018 because they are unchanged. And then other sections will say 2024 because they were modified last year. Anything you want to add on that?
The only thing I'll add is that there is a new bill, and I wasn't sure if this person was asking about it. The Senate Bill 5129, which is the trailer bill for WUCIOA, is still being negotiated and discussed. And if it passes, we expect some changes to take place January 1st, 2026, most January 1st, 2028, but some may take effect mid-year. So just keep checking the legislative website for the dates of when things are updated. All right. The next question is, what is a hold harmless agreement and when is a hold harmless typically used? A hold harmless agreement is a new covenant that is recorded against a single lot or a single unit and the association. It clarifies and even changes the rights and obligations of the signing parties that differ from those that exist in the declaration. It is a new agreement between the owner and the association, which will carry on with future owners because it's recorded. This helps avoid any disagreement down the road. It holds harmless or protects the parties from challenges to the new agreement based on the original documents. Typically, we see them for when an owner wants to modify the common elements, such as installing a heat pump, an EV charger, replacing windows. Sometimes we see it for short-term single-use occasions like managing insurance repairs or installing flooring or a skylight, or the use of some part of the property for a specific purpose. The example that someone added that was not me was having a horse on the lot. There was a hold harmless for just the duration that the horse was on the lot. The association is usually responsible for repairs, modifications, etc. of common elements, usually for restoring the unit after a damage event, but the hold harmless shifts that responsibility of certain components or other obligations to an individual owner that is requesting that modification. Ken, anything you want to add?
I think that pretty much covers it. Next question is SHB, which is Substitute House Bill 1500 regarding resale certificates. I think this is something currently in the legislative process. Will there be a new resale certificate from form based upon the changes being contemplated? And does the state issue the form and how do we get a copy? So the short answer is that the state does not issue any forms. Regardless of how they might change it, they don't have a form for the current resale certificate disclosures. But the statute is a checklist. And if you just go to the resale section, which is, I think, for Condo Act, it's 6434-425. I think it's 649640 for WUCIOA. It is a long laundry list of those pieces of information you need to disclose. And so when clients come to us and say, help us with a resale certificate, we start with, here is the checklist from the statute, fill in everything you can, and here's the list of documents you must provide. I don't expect it to be any different. There are businesses which work with a lot of management companies that create resale certificates, and sometimes they comply with the law and sometimes they don't. And those usually work where the association feed or the management company feeds in all the information about the association so that the computer can produce a form which is entitled the resale certificate at the top. And under the proposed bill, I think the contents of the resale certificate doesn't change. Instead, it's looking more for how much money can be charged and how timely it has to be prepared and how it has to be updated. But I'm not very familiar with it. But I would not expect the legislature to help you at all in complying with the law. Anything else, Katie?
Nope. So our next question is, in an RCW 6434 condo, the declarations and bylaws are silent on requirements for approving capital improvements outside the improvements identified in the reserve report. RCW 6434 does not appear to provide approval direction on capital improvements that are not listed in the reserve report. Are there other RCWs that apply in the approval of capital improvements that are not listed in the reserve report? Short answer is no. And I think it's important to note capital improvements and reserve components and expenses that are listed in the reserve study or reserve report are different. Capital improvements are additions to the property that don't already exist. So adding a new pool or sometimes security cameras if they don't already exist. Reserve components are components that already exist that the association can use reserve funds to repair. For example, your roof, your siding, those are usually reserve components in the reserve study. So nothing in the reserve study is going to be a capital improvement. The IRS definition of a capital improvement for purposes of depreciation or writing off an expense have no application to condominiums. Ken, anything you want to elaborate on?
There could be just the normal budget process that might have some implications, because if your community was looking to make a major expenditure during the year, it might be that it would show up as a line item in the budget, which the community has a chance to reject at the budget ratification meeting. But that would probably not apply if someone was actually using the reserve funds. I think if they were to use reserve funds for a capital improvement, they would have to comply with the obligation to notify the owners and elaborate on how they would replace those reserve funds within the following 2 years if it was not an undue hardship. So I think that, good practice would be that if you're going to make a capital improvement, meaning literally something new, not a replacement of existing, that you would be working with your homeowners to make sure they were supportive of it. Next question. I've heard a couple of times, quote, ask your attorney, quote, end quote, when you give answers. So this series of questions is, how do you evaluate law firms or lawyers? When do you know you have a good fit? And how do you search for a lawyer? We won't take an hour to do this, even though that's what they've suggested. So there are a couple of resources that can help. One would be, I would suggest you ask other condo or homeowner association boards who they use and if they like them. The CAI is certainly a resource. The local chapter has, I think, 35 lawyers listed as members of the of CAI, and you can get information about many of them there. We are certainly a member, and that list will hopefully help you whittle down some. Some of the law firms are very niche. and don't provide information or services to a lot of clients. So there are some which are very specific to construction defects or insurance claims, or they are developer focused for new communities, and you might be able to weed them out fairly quickly. Another CAI resource is that the National CAI has a organization called the College of Community Association Lawyers, and National CAI vets lawyers. There are, I think, 200 of them or so across the country as being qualified community association lawyers. We have 2 lawyers who are fellows in the College of Community Association Lawyers within our firm. I am a member, and Valerie Oman was inducted into the College of Community Association Lawyers this last year. But that is effectively the seal of approval from CAI. If you are trying to talk with law firms, I think that that's a reasonable thing to do. I don't know how successful you'll be in getting different law firms to just have an interview with you in order to see if there's a good fit, but we would normally recommend that. It is important that you have a common understanding with your lawyer of how much money you want to spend on things, because it's really easy to ask a lot of questions and get a big bill. And if you're okay with that, then that's the way to go. But I would say most of our clients are not excited about getting big bills. And so our default is to try and minimize how much time we spend unless we start getting direct requests from our clients. I think it's also important to try and anticipate what your bills are going to be. If you can specify a fixed amount of work, like a declaration amendment or a contract review, and have a fixed fee in advance, you will have a happier relationship with your attorney. I would say that the clients that seem least happy are the ones who are paying by the hour and get surprised by the size of the bill, even though they may not have been surprised at the number of emails they sent asking for advice. So, you have any other thoughts, Katie, on how to pick an attorney?
Only that if you don't like your attorney, you don't have to stay with them. You can shop around. You're not committed for just because you signed a fee agreement with someone 10 years ago and now there's a disagreement. You can move on. It happens all the time. You won't hurt their feelings, and don't stay in a relationship that you're unhappy with.
Well, you may hurt their feelings, but you still should switch. And it's, it is possible to change attorneys even in the middle of a collections action, even in the middle of some kind of litigation. And there are specific rules of professional conduct for lawyers. Even if you are in a contingent fee relationship where the attorney is getting paid out of the settlement funds, there are ways to change attorneys that are considered fair to both parties, and you wouldn't pay the first lawyer until you're done. So.
All right, so we are approaching our last question submitted in advance. I know that there may be 1 or 2 questions in the chat, and we will probably have time for more. So if you think of anything, feel free to pop it in. But the last question in advance is, these WUCIOA open meeting requirements are a real dilemma. I want transparency, but I want to get the association's business done too. Communication among board members between meetings has to happen. I have an idea for a virtual board working session. It'd be an online group messaging setup of some sort where board members read and post to each other. Owners can access to read, observe the workings of the board, but not post. It mimics a board meeting, but is not intended to substitute the meetings. From this, the board members are ready for well-informed decision-making when they come to meetings. Owners are more informed too and have a window into the board's process. Would this pass muster under WUCIOA? We don't know. Probably not. Unless every owner has agreed to electronic notice and you sent an email to every owner when any part of the discussion took place online, that might play a role. The open meeting requirement requires an owner comment period, and that is lacking from what has been described above. It says owners can observe but not post. We don't know if it would be different because you aren't making any decisions and you're just having a conversation. But part of the intent of the open meeting is that discussion is open to the members, not just the vote. The purpose of the statute was to encourage transparency. And this does not meet the goal for owners who use electronic notice, but who require paper notices. They're not going to be as involved because you're not going to print out the message board and mail it to everyone or send a letter saying, hey, we've posted on Slack. There is a benefit to real-time conversation and discussion that you just don't get from message boards. And the new meeting provisions will require that an owner forum take place at the beginning of each board meeting. This tells us that the legislature wants owners to be able to speak on agenda items before the board votes, not after the fact. Virtual working sessions with no opportunity for owners to comment likely violate that legislative intent. It's our thought that the above scenario would not pass muster under the new meetings provision currently under negotiation and likely to take effect January 2026. But we can't know for sure until either the legislature says something or the court says something. Ken, anything to add?
Well, I think that it is an innovative and maybe effective way of trying to have the board members be informed, but it does assume that the board members are actually participating in this all month long. And I can tell you from past experience that there are a lot of board members who don't do anything between board meetings and are completely uninformed. I mean, I've sat in meetings where the president, secretary, management company have provided significant amounts of information so that owners and board members can be informed before a meeting starts, and you start the meeting and people have not read any of it. And I think that the participation level anticipated by this process is unlikely to actually come to pass, which is sad. I mean, it's the apathy or lack of participation which makes it difficult to manage or be on many of the boards in our communities. All right, but I think that is done with our list. So if there are questions in the chat, we should.
So the first question is, can a board enforce no smoking on patios or limited common elements based on city or state laws if smoking is not covered in the declaration? If you have a rule. Generally, the board has the broad authority to regulate the use of common and limited common elements, which we have seen be used to adopt no smoking in common or limited common element rules. Does not affect the unit, but it would be a separate rule, you can't enforce the city or state law. Ken, anything you want to add?
Well, I'll say a possible exception. There are some declarations where they will say that a violation of any law is a violation of the declaration. So that might sweep it in. The bigger challenge is that most of the laws do not address residential property. They address commercial properties. And this has been litigated at the appellate court level, where the court basically said, yep, all these cities have these laws saying you cannot smoke within 25 feet of a window or door of a commercial property. And the problem is that the townhouses, which were the subject of the litigation did not qualify as a commercial property under the city's law. So there was no violation of law for the person smoking on their deck with the smoke going into their neighbor's window. So a lot of people think that there is a no smoking within 25 feet of anyone's window law, but there is not. There is a law only for commercial properties as defined by the laws.
There's a follow-up of what about smoking inside of a condo unit? And that is a lot harder to regulate. You could try and adopt an amendment that prohibits smoking in each individual unit, but that would need to be approved by many people, depending on what your governing documents say. And it's much harder to regulate. And if you're thinking of trying to prohibit smoking inside condo units, you should probably contact your association attorney to see if it's possible or advisable.
Yeah, there's a difference between prohibiting smoking and enforcing under the general annoyance and nuisance provisions in a declaration if the smoke from the unit is to a reasonable person an annoyance or nuisance to the neighbors. So it's not that you have no ability to regulate smoking inside units, but you can't prohibit it unless it is going to qualify as a violation of the documents in some other form.
The next question submitted was with regard to the hold harmless question. What needs to be in the governing documents written to require a hold harmless, or do specific things need to be listed? Do specific things need to be listed, or can the hold harmless be orally required at the board or architectural committee's discretion? Do you want to answer that one first?
Sure, I'll go with if the issue involved was covered in your declaration or CC&Rs, you would not need a hold harmless. You would do the hold harmless because it is a variation of what's required, or it is silent in the documents. You know, we see very few documents written addressing heat pumps and electric vehicle chargers. So those are appropriate to use an EV. The discretion or requirement typically comes because a modification requires approval by the board. And the board can make a requirement that a hold harmless be put in place as a condition of their approval. So if an owner is wanting to expand their deck on the back of their home and the board's willing to allow it as long as the owner pays for everything involved with the deck and any future repair or maintenance of the deck, then they could require a hold harmless be signed and recorded so that it's very clear with the next owner that the unit owner is responsible for maintaining that deck.
There was a clarification request that says hold harmless sounds like a board adopted policy, and that is kind of true. We usually see electric vehicle charger policies or heat pump policies include a requirement for a hold harmless. The hold harmless is the separate recorded document that actually changes the obligations that is part of a policy for the overall installation and maintenance of a component. All right, I think we have time for one more. If I can find a good one. Can the HOA association collect 1 year's worth of late HOA dues? Can we file a lien on the property? I think that this is a good thing to, the answer is probably. Your ability to file a lien on the property is either has to be in the statute or your governing documents, and you should contact your association attorney to see if you have lien rights. With the 1 year worth of dues, you're still in the statute of limitations, so that's good. But you would probably need to contact your association attorney for more specifics on this and how to proceed. or submit it next week for one of our collections attorneys to answer.
Generally, the statute of limitations for HOAs and all WUCIOA communities is 6 years. And under the condominium statutes is 3 years. So, you know, it would seem like if all you're talking about is collecting a year's worth, you can do that. The HOA Act does not have a statutory right to record a lien. The Condominium Act and WUCIOA do have statutorily imposed lien rights. And so that's one of the things which is better for HOAs and condos under WUCIOA is the collections authority, but that at the same time is being whittled down by statutes designed to protect people from having their homes taken from them for small dollar amounts. So it's, the legislature is kind of going both ways at the same time, and it gets very confusing.
And we are at 11:01, so that's it for today. If you have any questions for next week, submit them by 4 p.m. next Monday, and we will see you then.